Great presentation so far. Next, we're going to be talking about consumption lounges, how to address and mitigate risks that are inherent in that type of use. But also, as I was just pointing out, there is a serious lack of consumption lounges, permitted lounge spaces across the whole state. And as my presentation will go into, California's state law allows licensed retail outlets to allow on-site consumption if that is permitted by the local jurisdiction. So lounges are allowed under state law, but really the barrier is the local rules. Most local ordinances do not allow for on-site consumption or lounges, and the few that do either have not a whole lot of rules about how they should operate, or in the case of San Francisco, have a whole lot of rules and special forms and permits that one needs to obtain. And I chose San Francisco. If you are able to access all the other materials in the Dropbox, I uploaded the rules for San Francisco lounges, as well as their application forms and their ventilation requirements. And we'll kind of go into why those are some best practices that lounge operators should be following. So it looks like you've got it up there.
Yeah. Okay, so I guess we've done we have your standard disclaimer. Do you want to go through that again?
I can't actually see them though. Hold on one moment. Let me do this a different way so I can see my slides if you're going through them that way. So my disclaimer again, I'm an attorney, but this is not legal advice. And be sure to speak with an attorney individually if you have questions. And let me just get this going from mine slideshow. Okay. And I don't think people necessarily need to hear my introduction again. So let's go to the outline. I can't actually see what slide you're on, Ellen.
Why not? It worked last time, but okay, we're on the outline.
Okay.
Share Zoom?
Yes, share.
I am. I mean, I'm sharing it here.
You did slideshow.
Oh, I'm not. I see what you're saying. Yeah. Okay, thanks. All right, so I need to end the show in order to do that. Share screen.
There you go.
But I was already doing that, I thought. Okay.
No, now I can see it.
Go back to, okay. Okay, now I have to go back to the PowerPoint so I can make it bigger.
It's there. You just need to click back on the main thing that's open and then go to view slideshow from.
Right, okay. Play from.
Yeah, current slide's fine. Okay. Excellent. There we go. All right, so here's the outline. So first, we're going to walk through the current law on consumption lounges. Then we're going to the main part of the presentation is going to talk about these different risk mitigation strategies. And these are going to include having policies and waivers in place, proper staff training, air quality measures and odor control measures, other harm reduction measures, ensuring that you have the right product and exposure warnings, and having good insurance policies in place. And then we'll take a moment at the end to look ahead at potential areas of litigation, and then some question and answers. All right. So the current law on consumption lounges, and this is kind of what I was just starting to talk about, Malcurso Medicinal and Adult Use Cannabis Regulation and Safety Act allows licensed cannabis retailers to operate a consumption lounge if that's permitted by the local jurisdiction. The DCC, Department of Cannabis Control regulations, don't really provide that many additional restrictions. So really, you're looking to local ordinances for these operational requirements in California. And that's, for example, whether or not the lounge can be indoor or outdoor, what types of odor control measures are required, what types of special permits, if any, are needed. That's all going to be at the local level, which is a contrast to how some other states have done it, where they've built in more state rules at the law and regulation level in other states. Next slide. So what does Malcursa say about lounges? So this is Business and Professions Code section 26200G. Notwithstanding paragraph 1 of subdivision A of section 11362.3 of the Health and Safety Code, a local jurisdiction may allow for the smoking, vaporizing, and ingesting of cannabis or cannabis products on the premises of a retailer or microbusiness licensed under this division if all the following are met. Number 1, access to the area where cannabis consumption is allowed is restricted to persons 21 years of age or older. Number 2, cannabis consumption is not visible from any public place or non-age restricted area. Number 3, sale or consumption of alcohol or tobacco is not allowed on the premises. Next slide. So that's all Malcursa says about lounges. That's it. So now we have to go to the regulations. This is now in the Department of Cannabis Control Regulations, section 15407, sale of non-cannabis goods. And here, really, we're looking at subsection B is the relevant one here, which says B and C really. Notwithstanding section A, a licensed retailer or licensed microbusiness authorized for retail sales who operates a consumption area on the licensed premise in accordance with Business and Professions Code section 26200G may also sell prepackaged, non-cannabis infused, non-alcoholic food and beverages if the applicable local jurisdiction allows such sales. And then subsection C says nothing in this section shall be interpreted to prevent customers from bringing or receiving non-cannabis infused, non-alcoholic food and beverages from a restaurant or food delivery service for consumption in the designated consumption area on the licensed premise if the applicable local jurisdiction allows for such activities. And so that doesn't say a whole lot, but it says that you can allow local jurisdictions can allow this, and also they can allow sale of some prepackaged non-cannabis foods and beverages. And it also says that customers are allowed to bring their own sort of foods and drinks, you know, from a bottle of water if they want to, etc., as long as the local jurisdiction allows it. Next slide. So this is another section that deals with consumption areas. This is particular to consumption at licensed cannabis events. And so if you're having a licensed cannabis event and you want to have a designated consumption area, you need to restrict that area to persons 21 years or older. Make the cannabis event organizer needs to make sure that the consumption is not visible from any public place or non-age restricted area. Consumption of alcohol or tobacco is not allowed on the premises. All requirements of on-site consumption from the relevant local jurisdiction has to be followed. And the licensed event organizer is responsible for ensuring that rules regarding on-site cannabis consumption are followed. That's essentially what that one says. Next slide. So again, that's all that's in the DCC regs about consumption areas. So not a lot. We have literally one section of one statute and 2 different DCC regs that deal with cannabis consumption areas. And that's it in terms of state law and regulations that deal with cannabis consumption lounge at this time. There was a bill that had been proposed. I think it's 20. It might have actually been in 2022, but it was passed in 2023, AB 374, and then it was vetoed by the governor. This was the known colloquially as the Cannabis Cafe Bill, and that would have allowed licensed consumption lounges to serve non-prepackaged food and beverages, also to hold ticketed performances and other events if permitted by the local jurisdiction. So again, it was still leaving it up to the local jurisdiction, but it was you know, creating a little bit more allowance for what these entities could do. Now, arguably, there's nothing in the law right now that prevents lounges from holding ticketed performances and events again. So it's that part wouldn't have been so much a change as saying, oh, by the way, local jurisdictions, you can do this. And just in case you weren't sure, we're now saying in writing that you can. But anyway, this was vetoed by Governor Newsom. And if you read his veto statement, I meant to link to it here, but I can send it to you if you're curious. It mentioned concerns with indoor air quality and smoke-free workplace laws. And so that to me made absolutely no sense because this bill did nothing to change whether or not consumption would be occurring indoors or anything like that. So I thought that was very odd, his reasoning on vetoing this. But the Assemblymember Matt Haney does plan to bring the bill back with some amendments this year, so we'll keep an eye on that.
Yeah, it is. It has been reintroduced. It's AB
Oh, excellent.
775.
Great.
San Francisco. He's from San Francisco. Also, Stern's bill, SB 285, which did basically the same thing, is still moving and could move this year. Huh?
Allen.
I'm sorry, Allen's bill. It's an Allen
Mm.
bill.
I think one of
Sorry,
them
still
was
up to-
just one of them was just about the food and drinks, and the other one I think also addressed the events and performances. But
Right.
again, it's not really prohibited right now anyway, so that doesn't necessarily have to be in there. Next.
Oh, yeah, sorry, multitasking.
So
Woo.
here are some an example of a local jurisdiction. So recall a few slides ago, there's not a lot of state laws and regs about this. So where do we have to look? We have to look at local jurisdictions that have allowed this to see, well, how are they regulating at the state level? San Francisco has the most robust rules with regards to consumption lounges. They have special permits for it. They have actually two different types of facilities, type A and type B consumption facilities. Type A is if there's no on-site product preparation. Type B is if there is limited on-site product preparation. They have different structural requirements. There's a special application for this, and this is all done not through the OOC, the San Francisco Office of Cannabis, but through the San Francisco Department of Public Health. They are the ones that you're going to get your lounge permit from, their environmental health division. And I have developed a good relationship with them. They are even willing to send some of their city staff members to other jurisdictions to educate them about the ways that they've regulated consumption lounges in San Francisco and best practices and things like that. And they even have a list of some local permitted lounges that are welcome to allowing tours of their facilities. And I've, shared those resources with other jurisdictions that I've been educating about how to regulate lounges. So these materials should all be on the Dropbox for you as well as linked here. Next slide. Another example, West Hollywood. This has been in the news a lot because there were some actual cafes down there that were kind of pushing the boundaries of this, cannabis cafes. They don't have quite as robust of special permits and forms and requirements that are available, but I did link to their rules about their special zoning requirements and their operational requirements, and they do have a consumption area permit application there, so you can take a look at that. So, so now kind of moving into best practices. And so what are some ways that you can reduce the risks of being a lounge operator? And some of the risks are, let's just kind of go through these. I mean, there's the risk that really it deals with overconsumption, right? Or someone is consuming and then they leave your facility and they get in an accident, they injure someone, they do something stupid. So, and to what extent is that going to flow back to you? There's also the issue of making sure that you're just not violating any applicable laws and regulations when you're serving customers at the lounge, whether that be in terms of age requirements, but also things like making sure you're giving them the right warnings. So it's, as a best practice, I advise my lounge clients that they should, before allowing anyone in the lounge, have them sign off on the lounge policies that lists, I agree to do the following and I acknowledge the following. And those are going to include things like complying with the rules, but also include things like, I agree that if I feel like I'm unable to drive, I will, utilize the resources available and take a ride share or things like that. And it sets forth, just kind of the general policies that they have to follow, being respectful in there. You might just decide to maybe set a time limit for how long someone can spend in there, and we're going to talk about that a little bit later, the pros and cons of that. Basically having them acknowledge and agree to lounge rules, making sure these are clear. Don't use crazy amounts of legalese in here. It should be, a page, maybe front and back of one page. Don't make them flip through 20 pages of policies. Have it be clear, easy to understand. And you want to make sure that they're aware of and assuming the risk of entering the lounge. You want to have some indemnification language on there to protect yourself or, your client as the lounge operator. And you want to include some release language of current and future claims. So those are some suggestions for what to include in these policies, and they can also serve as a liability waiver as they're agreeing to the policies. So that's one kind of suggestion. Also, and this is super critical, training, making sure that your lounge staff are properly trained on various things, such as what the products that they're offering are, if there's recommended dosing, anticipated effects, onset times, and making sure that they're communicating this to customers that they're either serving, or if they see a customer that's ingesting one of these products, that they can answer these questions. Recognizing signs of overconsumption, over-intoxication. And this is something that, you know, if you work at an alcohol bar, it's a similar thing. And there's special training for staff of these establishments that'll train you. How can you tell the signs of overconsumption, over intoxication? And this can be tricky because cannabis affects everyone differently, and it's not like alcohol where it kind of hits you right away. Depending on the type of cannabis product you're consuming, it could take a while to hit. If you're there and you've consumed some edibles, you might not feel things for an hour. And you know, different people are going to feel it differently. So this is kind of you know, a tricky area, but always err on the side of being overly cautious and really look into these specialized trainings that exist for your employees. And checking IDs, this is very important. Avoid serving cannabis to minors. And it is 21 plus is what the lounge rules are. So even if you're a medical establishment and you're allowed to have medical patients there who are under 21, they can't be in the consumption lounge area. That's not allowable. And even if they had their ID checked when they first entered the dispensary, if they're now in this other room, that's the consumption room, there should be another ID check before they get in there. So that's pretty important. And so I note here that specific staff training is required under certain state laws, such as Colorado, Nevada. And I've looked into some of these companies, and they also offer their service to California companies. So do look into that. Next. So air quality and odor control. So this is often a complaint that is brought up when discussing consumption lounges in general, and a reason that they probably aren't more common across the state is because folks are concerned about smells escaping and also what's being breathed by people in there, right? So most jurisdictions that allow consumption lounges, have pretty strict air quality and odor control standards to reduce the possibility of their smells escaping from the lounge, but also to protect patrons and the employees from potentially dangerous exposures to chemicals that are in smoke, whether that, you know, there's lots of, when you combust anything, there's a variety of chemicals that are produced, and you don't necessarily want to be breathing that in all of the time. That is why kind of smoke-free workplace laws do exist. Now, there are no rules about air quality and odor control for lounges at the state level, other than there are indoor smoking laws that certain jurisdictions have raised as a reason to not allow lounges at all. But I think this is a future potential area for DCC regulation. If you look at some other states, I noted Nevada, for example, they have pretty in-depth rules that are in their state regulations now, cannabis regulations that deal with things like odor control and air quality. So I think the DCC might step in on that if these jurisdictions aren't really doing the same. But now, even if there are no requirements at the local level, other than the jurisdiction just says, sure, if you're a dispensary, you can have a lounge, have at it. Lounge operators should still, as a best practice, isolate consumption to a separate room in the facility, so that people who are just visiting the store, their work in the other area of the facility, don't have to be inhaling that all the time. You want to be installing proper filtration systems, and other operational measures to confine the smoke to whatever that designated space is. And that might mean having this be an outdoor area, right? And that was my last point. Consider using outdoor areas if possible. You then have a kind of a different issue, is now we want to make sure that the odor is not escaping to the sidewalk or wherever else, but it's a little bit easier to deal with that depending on where you're located. So let's go to the next one. These are some general just harm reduction measures, and some of these are a little bit repetitive. Double checking IDs, we already kind of talked about that. Limiting the amount of time a patron can spend in the lounge. This has, I think, some pros and cons. I think that why you might want to do this, or suggest that your client might do this, is so that you don't have people there literally all day just consuming, and then just being super overly intoxicated because they've been there for 8 hours, right? So that's why you might want to limit. Also, there's other people that might want to use the lounge, and if you're getting overcrowded, you might want to just kind of keep some kind of a turnaround time limit. The con of that is if you have this time limit be too short, someone might consume and they might have to leave before the product they consumed has really taken effect. And now they're just out, walking or driving home, and all of a sudden it hits them and they're not in that safe, comfortable space anymore. So there's kind of a, a balance there of how much time is the right amount of time if you're going to limit that. Also, hours of operation. I put this because let's say the dispensary is open until 9 p.m. You might not want to be letting people enter the lounge until 9 p.m. because you're about to close. And now they've just consumed and they have to be out on the street. So you might consider closing, limiting, stopping people from entering the lounge, an hour or 2 hours before you actually have to close your doors, right? You also want to best practice post reminders about responsible consumption inside the consumption area. Have some posters and some pamphlets about what is responsible consumption and dosing guidelines and how do you recognize if you've had too much. Also providing water and comfortable seating, right? So if someone starts to get lightheaded or overheated or dizzy, you do want to make sure that you have water available and some place to sit down, especially if people are doing dabs or anything like that. Be wary of combinations with other food and drinks. And I mean a couple of things by this. It could be that someone is eating or drinking something that's either prepackaged that you sold, to them, or that they brought in from outside. And that could have some reaction with the cannabis, or they could just have an unrelated reaction to the food that just happens while they're in your lounge. It might have nothing to do with cannabis. And so, that might be some reason why you might consider putting some limitations on what types of food and drinks you allow to be consumed inside the facility. Also allergies, if someone's eating something in there and it has peanuts and they're next to someone with a peanut allergy, now you have an allergic, situation at your facility that you have to deal with. So just be wary of those types of combinations and people mixing, too many different cannabis products together as well. And also you want to inform patrons about different rideshare and taxi options. Again, this can be have pamphlets. You can have a bulletin board with different rideshare and cabs and Ubers. You can maybe give them a coupon for a free Uber ride, or something like that, or a discount. You can work out something like that. But just encouraging folks to not get behind the wheel after they've consumed, if they feel really that they're impaired, is going to be your best protection as a lounge operator against negative consequences flowing back to you. Another thing you're going to want to make sure is that you provide proper warnings for the lounge area. And I picked Prop 65 warning here because it's about California, and California actually has specific warnings that you're supposed to give for environmental exposure. So like lounges, if you're in an area where cannabis is being smoked or vaped, there's this specific warning that has to be given. And this language just changed about a year ago. And this has to be on a sign that's at least 8.5 by 11. And the type has to be no smaller than 22-point type. And it has to be in like a box that's at the entrance and exit to the consumption area. This is in addition to warnings that might be required on the products. This is for the area. The smoking area needs its own special warning on big signs. And so this first slide here, 25607.46. This is the warning. This is telling you about how to transmit the warning for cannabis smoke or delta-9 THC exposure. And this talks about the sign for anywhere where smoking, vaping, or dabbing would occur. And if you're in an area, let's say, that has a large Spanish-speaking population and you have been providing other information in Spanish as well as English, then the sign also needs to be in Spanish. And so if you go to the next slide, this is the actual warning language for the environmental exposure for cannabis smoke and or delta-9 THC for the consumption lounge. It has to have the big yellow triangle, the word warning, and then the following language. And depending on whether it's an area where cannabis smoking and dabbing occur, or if it's just vaping and dabbing but not smoking, or if it's just vice versa. There's like 3 different versions of this warning. In most consumption lounges, they'll be both vaping and there'll be vaping, dabbing, and smoking. So you'd want to pick the broadest one of these. And so that would be this subsection big A, which is breathing the air in this area exposes you to cannabis smoke, which increases your cancer risk, and during pregnancy exposes your child to delta-9 THC and other chemicals that can affect your child's birth weight, behavior, and learning ability. For more information, go to www.p65warnings.ca.gov/cannabis. And so that's a lot. This is what it would look like. And it has to be on a kind of in a box. This is not quite what it would look like, but this would have to be in a box and posted at the entrance and the exit to the consumption area. And it's at least 8.5 by 11 sign and at least 22-point font. So that's for warnings, and just the area. Again, the products themselves also likely need warnings. Insurance policies is another way that you can mitigate some of these risks, is be insured for this. Now, if you have an insurance policy, you're going to want to read it pretty carefully, because a lot of them exclude consumption activities. A lot of them exclude federally illegal activities. So you want to make sure that neither of those apply to your policy. And there are specialized like insurance providers that serve the cannabis industry, including for lounges. So do make sure that you are looking for one of those. They do exist. Next. Okay, so now we're kind of talk about some potential areas for litigation and where this might go next. So up here is California's law for social host liability for alcohol. This is in Civil Code section 1714. And this has to, if you kind of skip down here, basically this is saying that everyone's responsible for not only his or her willful acts, but also certain injuries that they bring apart, except if you skip down, no social host who furnishes alcoholic beverages to any person may be held legally accountable for damages suffered by that person or for injury to the person or property of or death of any third person resulting from the consumption of those beverages. And then so that's basically saying social hosts. If you have people over for drinks, you wouldn't be liable for any damages if someone else gets drunk and then injures. But there is an exception if there's a parent, guardian, or another adult who knowingly furnishes alcoholic beverages to someone they knew or should have known was under 21. And then that minor basically injures someone. So that's the social host liability for alcohol. And so basically really the only chance that would apply again is if you were an adult and you served alcohol to someone who you knew or should have known was a minor. Next slide. And so that's for just social hosts. This is the California law for, it's called a dram shop law. This has to do with like alcohol serving establishments. This is in section 25602.1 of the Business and Professions Code. Notwithstanding subdivision B of section 25602, a cause of action may be brought by or on behalf of any person who suffered injury or death against any person licensed or required to be licensed pursuant to section 23300, those are alcohol licenses, or any person authorized by the federal government to sell alcoholic beverages on a military base or other federal enclave, who sells, furnishes, gives, or causes to be sold, furnished, or given away any alcoholic beverage, and any other person who sells or causes to be sold any alcoholic beverage to an obviously intoxicated minor, where the furnishing, sale, or giving of that beverage to the minor is the proximate cause of the personal injury or death sustained by that person. So again, the only way that you'd be able to bring, a cause of action against this licensed alcoholic establishment for these injuries is if they sold alcoholic to a minor, right? So next slide. So why am I talking about this? We're in a cannabis seminar. Why am I talking about alcohol? Well, because there's a question about like whether or not this type of a standard is going to ultimately apply to lounges and employees. Is the state going to create some kind of a carve out where, licensed retailers and licensed lounges are protected against these lawsuits unless they serve to a minor? So that's kind of why I'm bringing this up. We'll see. And this is kind of what happened in Nevada. Nevada, they updated their law. We're looking here at Nevada Revised Statute Section 41.1307, which is new. It was enacted in the last like year or two. And it comes right after their similar section for alcohol. And now it's talking about liability for serving cannabis, in cases where they're under 21 and damages for that. So I thought that's interesting. And so it's kind of yet to be seen if, how this is going to work out in California. Is there going to actually be some like statutory addressing of whether or not when there's going to be liability or not liability of these establishments, or is it just going to kind of develop in case law, maybe looking to how things have worked out in the alcohol context. So, regardless, I think it's clear that there are going to be lawsuits that will be filed. So assume that liability is a possibility and just do as much as possible to mitigate the risk. Okay, and you got some questions.
So we're running a little behind. I had hoped to start lunch about 10 minutes ago. There are a few questions from people online that maybe Lauren, you could type some answers to. You can see the questions, correct? You just can't ask one yourself?
Yes, I can see the questions.
You answered Bob Boyd's. What are your
Okay.
thoughts on charging for entrance or consideration? And then someone's confused about what can be done now. I mean, cannabis cocktails are okay to sell. We're mostly talking in these new laws about non-cannabis or non-alcoholic beverages. And then, yeah, you can have something delivered from next door. I don't know about the entrance fees, so
Entrance fees, I don't know. I mean, I think if it's a special event, perhaps, there's nothing in the state law that says they can't charge a fee just to use their lounge. I don't think that's a great practice, especially since for many people, this is like they might need to have a safe legal space where they can consume their medicine. So just as a public health community safety measure, I think it's better for lounges not to be charging people access just to come in and use the lounge. But if they had some kind of a special event going on, I could see, if they are doing a ticketed event of some kind, I think that's perfectly fine. And then I think that was all the questions, right? Because yeah, just to address Michael Chernus's question about what can they do, no food, no drinks. Yeah, so I mean, it's prepackaged food and beverage, but you are allowed to kind of bring in some foods from outside, which is why that one that you mentioned that's bringing Sue from the restaurant next door, that's kind of like been their workaround. And then hopefully we will get some legislation that will allow lounges to actually prepare and serve non-alcoholic food and beverages there on site. And we'll see if and how and when that might pass.
and then Dale has a quick
Yeah,
question.
I just wanted to make a point about the ventilation issue, which is likely to be dealt with this year in the whatever consumption lounge bill goes forward to the governor. But in the meantime, I would note, I would not necessarily recommend San Francisco's ventilation regulations are by far the most exorbitant in the state. They require what's called negative pressure rooms, which cost hundreds of thousands of dollars to install. And you can't even have a negative pressure room that, for instance, opens out to a patio because you can't maintain negative pressure then. There are other places. West Hollywood has the most liberal rules now. Basically, their rules require that the odor not impinge on neighboring properties, which are pretty reasonable. So I would be more inclined to recommend those as opposed to San Francisco's. And we're hoping that we can come up with something that is not as overboard and costly as San Francisco's regulations. But
that's a great point. We can't have these rules be so onerous that operators are not able to comply with them.
Okay, was that a question?
I was just gonna say Santa Ana has the same liberal restriction on lounges as West Hollywood, where just don't impede. Our retailers largely have just been told, because odor control was required in the retail establishment, you're probably good. With kind of speakers inside and outside as well, as long as they can't see it or what have you.
Okay, great. All right, so